Extending a very good morning to all the dignitaries on the dais, respected participants of the dais, and all the staff organizers of this program, students. So we are in the second day of the 3-day Capacity Building Program on Consumer Protection Act 2019 for the presidents and members of State and District Consumer Dispute Redressal Commissions of Tamil Nadu, Andhra Pradesh, Telangana, Puducherry, Andaman and Nicobar Islands. So, first of all, I request all of you to raise for the invocation.
செம்மை செய்பவல்லியே மாண்புகள்லியே என் தமிழ் தாயே வீழ்வாரை வீழாது காப்பவல்லியே வீரனின் வீரமும் வெற்றியும் நீயே தாழ்விடு நிலையினில் உனை விடுப்பேனோ தமிழனின் நாளும் தலைகுனிவேனோ சூழ்ந்தின்பம் நல்கிடும் பைந்தமிழன்னாய் தோன்றுடல் நீ உயிர் நான் வளர்ப்பேனோ செந்தமிழே உயிரே நருதேனே செயலினை மூச்சினை உனக்களித்தேனே நைந்தாய நெல்லைந்து போகுமென் வாழ்வு நன்னிலை உனக்கெனை எனக்கும் தானே முந்திய நாளினில் அறிவுமில்லாது மொய்தனன் மனிதராம் புது புனல் மீது செந்தாமரை காடு புத்தது போலே செழித்த என் தமிழே ஒளியே வாழி செழித்த என் தமிழே ஒளியே வாழி செழித்த என் தமிழே ஒளியே வாழி.
Thank you all. Now it's the time to welcome our respected guests. And so now I request respected Professor Dr. S. Srinivasan sir, Principal Dr. AGLC, to welcome our dignified guests.
The most respected, Honorable Lordship, the Chief Justice of Madras High Court, the President of the National Commission for Consumer, AP Sahi Saab, and Honorable Justice Senthil Kumar Ramaswamy, and respected the former Vice Chancellor, National University Bhopal, and respected Senior Advocate Mr. Srinath, and respected the member of the Legislative Assembly of this constituency, the participants, my faculties, and my dear students, and all others who are present here. It's a very pleasant good morning to Punadam. So today, it is a blessed day. It's a great day for Dr. Ambedkar Government Law College for the reason that we are all able to be in the midst of great personality sitting here. I think you can understand that we are conducting a 3-day capacity building program for district judges. So the amount of interest that the Honorable Chief Justice has taken to come over and to speak to you, to share with you, that is something great that you must have seen anywhere in the country. So first of all, on behalf of all of you, I would thank the high dignitaries present here on the dais. Lordship, I have bounden duty to inform you that this 3-day capacity building program is being conducted based on the proposal sent from Dr. Ambedkar Government Law College some 2 months back. So I, in the capacity of Principal, Dr. Ambedkar Government Law College, has addressed the Secretary, Minister of Consumer Affairs, 3 proposals. Proposal number 1, seeking financial assistance for conducting All India Motor competition. Proposal number 2, seeking financial assistance for conducting a 3-day capacity building program for the consumer judges for 5 states. And third proposal is about seeking a consumer chair for Dr. Ambedkar Government Law College. So out of these 3 proposals, the Minister of Consumer Affairs have been so generous enough and gracious to approve 2 proposals. Proposal number 1 for All India Motor competition and proposal number 2 for capacity building program. And the third proposal regarding the constitution of a consumer chair in Dr. Ambedkar Government Law College is under consideration before the Consumer Ministry, where we have a 1 crore deposit for a period of 3 years for the purpose of conducting various activities on consumer related matters. So hope that is also will come up in the course of time. So I take this privilege, and I feel that it is a more honor that the dictator is given to me and to my institution. So our institution, my lord, has been a very pioneer institution, more particularly in South India. and have completed more than 53 years of its existence. To start with, it was the Dr. David Sabi who was a founder principal that started this institution in 1972. And this institution has produced many legal luminaries all over the country. And they are occupying good position all over the country in various states. So such a legacy this institution has for last 53 years. And even I have spent, Lordship, I just want to convey very proudly that I have spent about 40 years of my life, out of 62 years now, in the same institution as a student and as a faculty and as a principal of the institution will retire next year. Sorry, this year. I have a desire to retire next year, but fortunately I will retire this year. So I take this special opportunity to welcome our Honorable Chief Justice of Madras High Court, who has come all the way to share and meet you personally, share our students who are here, participants who are here, and speak to you on various issues. So on behalf of the institution and on behalf of participants, on my behalf, I extend a warm welcome to you, sir. And AP Sai Saab, so he has been instrumental in conducting the second edition of this capacity building program. So the first edition was conducted with him in the same hall last year. So he was instrumental in again maneuvering as to the scope of sending a proposal to the university and requesting the ministry to conduct or seek a financial assistance to conduct this program. So all that have been, he has been instrumental in that, and he is here with us today. So the second edition of this capacity building was able to be conducted with his background and support and help. So thank you, Lordship, for your support and help. And I take this opportunity to welcome our AP Sahid Saab. So he's always with us in the promotion and development of our institution in conducting various activities. And Mr. Namachai, who is supposed to be with us and will be sharing the program tomorrow and on a personal visit to Chennai. So he has been instrumental in conducting various programs as an education minister, and he has been a motivating factor. And also he has been helping me and supporting me in all activities. So thanks to our Honorable Education and Home Minister on this occasion. So his absence will fill away tomorrow. So thank you, sir. And Honorable Justice Chandra Kumar Ramaswamy. So the day on which I entered this Chandra Kumar Ramamurthy. So the day on which I entered his room, I did not get any negative vibration. It's absolutely a positive vibration. So the moment I started telling him, he has understood and he is inclined to come and participate in the function. And I did not expect with this busy schedule to immediately involve and commit to attend this program. So thank you, sir, for all your support and for me. And sir will be sharing his student along with Mr. Srinath, Senior Council. So it's going to be a brainstorming program and a session. So we will be witnessing it. So thank you, sir. Taking this opportunity, I welcome our Honorable Justice Chandra Kumar Ramaswamy, sir. Thank you, sir. And our Honorable Vice Chancellor of the National University. So even the last program he was there, and of course in every academic activity he is there. And he is the one who was instrumental in converting this academic institution into a training institution. So Lordship and other dignitaries here will know that how difficulty is to conduct regular classes for the government institution, in a government institution, with the basic infrastructure, shortage of infrastructure. With all that, we are able to manage the classes, conduct various academic activities, and we are also able to conduct various training programs, and it is his own guidance, and we are able to do that successfully. Lordship, we have conducted a training for the police officers. Lordship, we have conducted a training for the administrative officers. Lordship, we have conducted a training program for the faculties of the all colleges, or all three criminal laws. So that way, the government law college, this education institution, is now turning to be a training institute. With the support of this government, the Honorable Chief Minister will never say no to any of my activity which is conducted here. Being
Okay, the second day program has been inaugurated successfully. Now it's the time to honor our dignified guests. First of all, I'm requesting Principal Professor Dr. S. Srinivasan sir to honor Honorable Mr. Justice K.R. Sriram sir, Chief Justice, Madras High Court. Next. Next, I am inviting Srimati Lalita Tripura Sundari, Assistant Professor Dr. AGLC, to honor Honorable Mr. Justice A.P. Sahi, President NCDRC, New Delhi. Now, I am inviting Ms. Sukanya, Assistant Professor Dr. AGLC, to honor respected Honorable Justice Senthil Kumar Ramamurthy sir, Judge High Court, Madras High Court. Now I invite Dr. S. Vijayan, Assistant Professor, Dr. AGLC, to honor Shri L. Sampath, MLA, Puducherry. Now I am inviting Mr. Abhinav Gupta to honor Dr. Vijay Kumar sir, former Vice Chancellor, NLIU Bhopal. Next, I invite Dr. Madhivanan, Physical Director, Dr. ADLC, to honor Thiru Srinath Sridevan, Senior Advocate, Madras High Court. Now I invite Honorable Mr. Justice K.R. Sriram, Chief Justice Madras High Court, to give his inaugural message.
Honorable Justice Sindhil Kumar Ramamurthy, Honorable Mr. Justice A.P. Sahi, President National Consumer Advocacy Commission, Shri Sampath, Member of Legislative Assembly, Puducherry, Professor Dr. Vijay Kumar, former Vice Chancellor, National Law Institute, Bhopal, Dr. Srinivasan, one of the distinguished lawyers of Madras High Court, Shri Srinath Sridevan, President and members of the State and District Consumer Dispute Redressal Commissions of Tamil Nadu, Andhra Pradesh, Telangana, Puducherry, and Andaman and Nicobar Islands. Members of the organizing committee, distinguished guests and participants, ladies and gentlemen. A very good morning to all of you. It was really a great honor for me to address the distinguished gathering here. This program, organized by the Government of Puducherry and Dr. Ambedkar Government Law College, Puducherry, under the aegis of the Ministry of Consumer Affairs, Food and Public Distribution, Government of India, is a remarkable step in enriching the understanding and capabilities of the members tasked with the critical role of adjudicating consumer disputes. As we reflect on consumer rights in India, it is essential to recognize that these rights emerged much later than the commencement of the Constitution. The concept of rights has graduated over a period of time, from philosophical underpinnings to statutory rights, and further to constitutional and fundamental rights, all aimed at better promotion and protection of the individual. It is evident that the concept of consumer rights is given less attention than other right-based approaches like human rights. Recognizing consumer rights as human rights reinforces inherent value and importance in ensuring well-being across nations. Consumer rights in India were established as statutory rights with the enactment of the Consumer Protection Act 1986. This significant legislative initiative marked a pivotal role in advocating for consumer affairs, ensuring that consumers were adequately protected in transactions against unfair practices. As there were gaps, it came to be addressed, it was sought to be addressed through the Consumer Protection Act 2019. This act represents a significant advancement in consumer rights legislation in India. It is a comprehensive law designed not only to protect consumer rights but also to empower consumers in a rapidly evolving marketplace. In 1991, India initiated a series of economic reforms that liberalized various sectors of the economy. This included reducing trade barriers, deregulating industries, and encouraging foreign investments. The result was entry of multinational corporations in various industries, including retail, telecommunications, and e-commerce. Liberalization has encouraged competition in these sectors. As a result, consumers have more choices and options in almost every sector. However, while liberalization and globalization have brought many benefits, they have also raised concern about economic inequalities, particularly in rural areas where the benefits of globalization may not be as evenly distributed. Ensuring that all consumers, regardless of their geographical or economical status, have access to the advantages of liberalized market is an imperative that we must strive for. The 2019 Act provides several legal rights to consumers which are intricately associated with various legislative frameworks. Consumer rights are also actively enforced through judicial decisions rendered by the Apex Court and the various consumer fora established across the country. These decisions further eliminate and define the contours of consumer rights, ensuring that consumers can effectively assert their entitlements in the face of disputes. 19 Act comes with a robust set of features designed to strengthen consumer protection mechanisms, some of which are like the establishment of the Consumer Protection Authority to serve as a watchdog. The Act introduces a simplified dispute resolution process, including establishment of mediation cells. It expands the definition of consumer and recognizes the emerging forms of consumer transactions that occur in today's digital age. It also emphasizes the importance of alternative dispute resolution mechanisms. The essence of consumer protection legislation lies not merely in drafting laws, but in fostering a culture that recognizes and respects consumer rights. The Act enumerates the 6 fundamental rights of consumer, which are right to be informed about quality, right to choose according to their preference, right to seek redressal against unfair trade practices, right to consumer education, right to safety, right to be heard, etc. As adjudicators, it is your solemn duty to uphold these rights with prudence and empathy in the cases that come before you. The empowerment of consumers is intrinsically tied to their ability to assert their rights. Therefore, effective redressal mechanisms must be established as a cornerstone of our consumer protection regime. As we acknowledge the advancements in consumer protection brought about by the 19 Act, it is essential to highlight the transformative role of information technology in reshaping how consumers engage with goods and services. Information technology, as we all know, has fundamentally changed this landscape of consumer transactions, introducing unprecedented convenience and efficiency. With e-commerce platforms and digital marketplaces at their fingertips, consumers can now browse, compare, and purchase products from a global marketplace with just a few clicks. This democratization of commerce allows consumers to make informed decisions based on reviews, ratings, and detailed product descriptions. This IT-driven ecosystem, however, introduces complex legal and regulatory challenges. Fake reviews and unauthorized use of consumer data pose significant risks, while the absence of physical interaction in these transactions leave consumers vulnerable to unfair trade practices. Into the healthcare sector accentuates the importance of protecting patients against negligence. Patients, as consumer of medical services, are entitled to various rights under related laws. These include right to be informed about their medical condition, treatment options, potential risks, the right to confidentiality regarding the medical information, the right to receive quality medical care that meets acceptable standards, the right to be protected from harm or injury while receiving medical care, and the right to seek compensation for any harm or injury suffered due to medical negligence. The issue that has always come across, because I've also had few medical instances, when I'm asked to sign a consent form, say, I agree for this procedure to be done on me. Dr. So-and-so, I say, explain it. Is it informed the decision that I'm making? That's always bothered me. Do I have a choice? In one instance, I'll tell you of my own case, where I was performed, they said, Doctors X and Y explained to you the procedure, and you please sign at the bottom. I said, I haven't even seen it. So they said, they have explained it to your spouse. I said, take her signature. So they said, but you're conscious. I said, so? You ask it to come and explain to me. So they said, no, they are not available now, they'll come only in the evening, but we need to ready you for the procedure. So you need to sign. I said, I refuse to sign. And I can only tell you, you pray, I don't get out of alive this place. Because I'm not going to scare you. Because I said, you give me a blank paper on which you write, I allow you to do anything with my body for the treatment I need. I will sign it because that's what I can do. That's the truth. You cannot make me sign on a form which is incorrect, because if I had signed the form that was given to me, I would be signing an incorrect document, which is not the truth. It's something which, if we are going to do this kind of procedure, it could be laparoscopic, and in case it does not succeed, we find some blocks closer to your aorta, we may have to rush you to the operation theatre, open and do an open heart surgery. Are you, as a patient, going to say, I don't agree with you? You're scared. You have no choice. This is something which has not been really tested, which I would request you all, if you get an opportunity to test it in the right direction. Have a dispassionate view. We have to consider what does the doctor do. He has also no choice but to give this, because if he does not take this consent, his medical negligence insurance claim will be rejected. So these are various issues. Just think over it. I'm only throwing up a problem. Please find in your tenure if you can find a solution to that. Another issue, part is the medical insurance, is another core sector. It operates on the principles of contract law, wherein insured patients must provide accurate and comprehensive information. As failure to disclose pre-existing conditions or relevant medical history can lead to denial of claims, creating significant hardship for consumers. Who would have made that utmost good faith? We have had brother Justice Sandhar Kumar Ramamurthy, who is my bench partner. We have seen quite a few matters where banks, while giving loan, they sell a policy. In case you borrow or die, the insurance company will pay off the loan. Now the insurance companies, the bank is A Limited, and the insurance company is A Insurance Limited. It's owned their own group company. So their business goes up, bank is also able to sell. And there have been so many cases we have got in 226 jurisdiction saying that insurance company and bank has to collect the money from the insurance company. I don't have to come, my children, we are only the legal heirs, why should we be discharging the liability? But they are not informed that these are the three conditions, because the one who comes and takes your signature is only a broker, only an agent. Nobody comes from the insurance company to explain to you. Let's take it. We are all, even we wouldn't be so much aware as to what is to be done. Look at somebody of Puducherry in the village taking an education loan for his son or daughter to go abroad or for higher studies. They wouldn't even know what they are doing. So these are the problems which you could come across. Because insurance law mandates that process claims is claimed in a timely manner. Consumers have the right to receive clear and comprehensive information. Many a times you will come across cases where the insurance company would raise the issue of limitation. He says, oh, you never rejected my claim. So, but they think that only when the claim is rejected that the time starts. So these are all issues which you need to, of course, many a times the person coming to you before you would be an individual. Your emotions will also have to be kept in check because you have to go as per what the law prescribes. There was a case in the case of Katema Fibers versus New India Assurance Limited, where the apex court reinforced the principles that ambiguities in insurance contracts must be resolved in favor of the insured. I will tell you two instances. I will just mention to Justice Sahi briefly. When I was a lawyer, there was a matter of an insurance claim that was lodged by my client for a total loss claim of a very large ore and oil carrier, VLOO. She was on her funeral voyage from Alang Anchorage to the Anand Shipbreaking Yard, a distance of near 9 kilometers. The vessel lost her rudder. She was doing on self-power. She was a twin screw, 20,000 bhp, two engines, but only one was working. And she lost her rudder, drifted, sat 3,000 feet away from the designated yard where she was to reach. 3,000 feet is not too far, but I started out by saying very large ore and oil carrier. And Alang is a tidal port. So every morning there is a high tide and then the water ebbs. So when she sat, she went up the next day because only at high tide she was going to the beach. Otherwise she will touch the bottom. Next morning she went up, water ebbed, she went down. Next day again she goes up, she goes down. and she broke her back. So the vessel could not be even moved from there, so we launched a claim saying she has lost her species. She's no more a ship, it's only a wreck. And the matter was before NCDRC, the then former Chief Justice of India, Mrs. M.B. Shah, was the president of the commission. I'm talking of mid-90s. And both parties agreed because this required a lot of evidence to be led. One was the issue where there was the issue of non-disclosure, because the insurance company took the defense that the fact that only one engine was working was not disclosed, which was a material fact, and hence we were justified in rejecting it. And the issue was, did the insured disclose the fact that she had only one engine? And in the insurance proposal, the assured form annexed a copy of the agreement of purchase. And the fact of only one engine was working was in the annexure addendum to the agreement. So the insurance company said the addendum we did not receive, whereas when we said agreement means a complete agreement including the addendum. So the issue was whether the addendum was given, because the whole thing revolved on that particular issue. Non-disclosure, we are out. And then with the consent, both parties agreed, we let evidence of 4 from our side and 3 from the insurance company's side. It was quite an interesting. I wouldn't go into the details, further details. We had, of course, the owner, a naval architect, a master mariner, overall, and an expert in this insurance shipping industry. They were all examined. Long term, so a good bonus day for the lawyers also. End of the day, we succeeded. The NCDRC gave the order, allowed our claim for total loss. The insurance, the interest awarded was 9%. Cost of 10,000 rupees was ordered to be paid to the legal aid services authority. This is the key where I was coming to. Our argument, of course, both sides went to the apex court and it was thrown out in half a minute. But what I was saying is, yes, in normal circumstances, we would award 6%, 9%, at times 12%. In extreme cases, you would have come across 18% is also awarded. But here is a person, the insured had borrowed money at 19.5% interest from the bank. The insurance company, rightly or wrongly, they felt they were right and we proved they were not right. Rejected our claim and we had to wait for almost 4.5, 5 years to get the money. Just imagine. The value of the ship was 26 crores. We sold it at scrap for 13 crores. 12.5 crores, 13.5 crores was the insurance claim. On that, you are looking at 10.5% interest, that is 1 crore 35 lakhs per annum, is the loss that the assured has suffered. Certainly the lawyers are not cheap. The bill was close to 1 crore rupees, the legal fees. And the costs incurred we had appointed a retired Chief Justice of the High Court as the commissioner to record evidence. The witnesses had to be called from outside and they had to be put up in hotel, transportation. So much of cost was incurred in 10,000 rupees. What I'm saying, which will form a deterrent. People won't simply reject for the sake of rejecting. Because today it's a free lunch for everybody. So what? Court they will allow 3,000 rupees cost. I've seen orders being passed by Consumer Forum, 3,000 costs, 5,000 costs. Yes, you're awarding damages, but damages also has to be quantified. Sometimes I wonder how did the Consumer Forum decide 50,000 is enough as damages as against the claim of 10 lakhs? Why not 1 lakh? Why not 10,000? Because it might, certain things would have gone across in your mind as to how you determine, but that has to be seen, to be articulated on paper. This is just a piece of advice which I am giving because of the experience I've had. Another 5 minutes, please. Recently, I've had a chance to interview candidates for the Maharashtra when I was a judge in Bombay. I interviewed candidates for State Consumer Forum and District Forum as members. Quite a lot. And I was very happy to note again, I've said that in Chennai quite a few times, there were more lady participants during the interview than men. A lot of them came saying, I said, what? Of course, the whole interview process was stayed and quashed by the High Court. That's a separate aspect. And got stayed by the Apex Court because the rules provided for the judiciary to take precedence and not the bureaucracy. There were 2 IAS officers, excellent persons, who gave me a free hand. Many of them came and said, I said, why do you want to take up this course? Oh, I feel for the misery of various consumers. I used to be an activist. I have personally felt cheated when I went to buy a refrigerator. I mean, you're all there to decide a matter on the basis of law. You're not an activist. If you're an activist, be out of the judiciary, go file complaints, file PIMs. But when you're sitting on the dais on that chair, you're sitting there as a judge to judge who's right, who's wrong, and then give your finding accordingly. Because the person's approaching you, whether it's a claimant or the respondent, is looking to you for justice. The claimant will feel wrong. He says, I want justice, I want the price of my washing machine back. Whereas the company will say, I'm also looking to you for justice because it is not my fault, he mishandled it. So don't hold me liable for that. So both sides are looking to you for justice, and you are there to deliver justice, not be an activist to protect everybody. You will also come across various claims, particularly with regard to medical negligence. How do you decide whether the doctor was wrong or whether the hospital was negligent? There could be a lot of cases where you can easily, like for example, you say, I supplied this particular air conditioner, it just got out, there was no power failure. Easy, not so difficult for you to decide, but to decide whether the doctor was negligent or did not provide the required service expected of him is a complicated issue. You will have to decide how you want to go about. Justice Sai was saying that it's a lot of it is on evidence filed by affidavit, but a lot of things I personally feel would also require the party to be cross-examined because the evidence affidavit is prepared by the lawyer. So, saying all that, capacity building, going back to my prepared speech, capacity building is an essential endeavor for enhancing the efficacy of consumer dispute redressal systems. As a member of the Consumer Dispute Redressal Commissions, your role is crucial in interpreting and enforcing the law effectively. You are the custodians of consumer rights and as such bear a solemn responsibility to administer justice in a manner that is fair, prompt and accessible. You must remain abreast of technological advancements and their implications for consumer rights. This awareness will not only aid you in adjudicating disputes, but also in proactively engaging with consumers to foster a more harmonious consumer marketplace. Despite the robust framework of the 2019 Act, challenges remain. Successful implementation rests on the collaboration between various agencies. Therefore, this program initiated by the organizers is a significant step towards a better understanding of the Act, thereby enabling its enforcement in a more purposeful manner. My compliments to the organizers. As we delve into the intricacies of this act, I urge each one of you to embrace the learning opportunities presented here. The expertise you will gain from this program is not only an enhancement of your individual capacities, but also a collective strengthening of the framework within which we operate. The discussions and training sessions designed in this program will equip you with the necessary tools to navigate the complex landscape of consumer disputes. Your engagement in this capacity building program is a proactive step towards addressing the disputes and challenges effectively and in a manner that earns the trust of the consumer populace. I solicit each one of you to take full advantage of this initiative. Your role in protecting consumer rights, be it in the marketplace or within hospitals, can have a profound impact on society. The dedication you show in promoting and safeguarding these rights will contribute to a more just and equitable environment for all consumers. Your role as members of the commissions is not merely a formal obligation, it is a profound commitment to the welfare of society. Embrace the opportunity to further your learning and enhance your capacity to serve justice. Together, let us strive for a systemic transformation that recognizes consumers as not just entities to be protected, but active participants in a vibrant economy. Thank you for this opportunity to address you. I wish you all a fruitful and pardon me, I crossed the boundaries. I would urge all the speakers. I would request all the speakers. I like to tell stories. I would urge all the speakers to also speak from their personal experience in various matters because that helps us understand better. God bless all the very best.
Thank you, sir, for edifying all of us with your inaugural address. Now I am so glad to announce on a book release accompanied by a pen drive release on fundamentals of consumer protection law for judges and legal practitioners. So I request Honorable Mr. Justice K.R. Sriram, Chief Justice Madras High Court, Chennai, to release the book accompanied by the pen drive. Thank you, sir, and thank you all the dignitaries for releasing the book and pen drive. Now it's the time to give thanks to all the dignitaries, and I invite Mr. Abhinav Gupta, Assistant Professor, Dr. AGLC, to give the vote of thanks.
A very good morning to everyone. I would like to thank, on the behalf of Government of Puducherry and Dr. Ambedkar Government Law College, Honorable Chief Justice K.R. Sri Ram. So first of all, thank you so much for writing the foreword for the book, and we are really honored to have you today. And I'm sure every one of us listened to you. It was so fascinating to hear the examples which you shared with the participants. They'll certainly carry the food for thought for many days to come. In fact, I'm very happy to tell it was sort of a crash course for all of us. So possibly you covered all 3 days in just 20 minutes. Thank you so very much, sir, for coming here and enlightening us. I would like to thank Honorable Mr. Justice A.P. Shahin, sir, for being with us in the second edition as well. And we are very eagerly waiting to listen to you in your session. Thank you so very much, sir. In absentia, I would also like to thank Honorable Minister for Home and Education, Mr. A. Namashivai. I would also like to thank Honorable Mr. Justice Senthil Kumar Ramamurthy. Sir, you're very humble and we are so honored to have received you today. And we are eagerly waiting to listen to the jugalbandi between you and Mr. Sridevan. I would also like to thank Sri L. Sampath, MLA Puducherry. Thank you so much, sir. Your alumnus is very proud of you and thanking you for always being here when we need you. Thank you so very much, sir. I would also like to thank Professor Dr. V. Vijay Kumar, my guru, my mentor. And thank you so much, sir. I am here because of you. And thank you for making who I am. I would also like to thank Mr. Srinath Sridevan. Thank you so much, sir, for accepting our invitation. And we are just waiting to listen to you. Now, on behalf of the principal and faculties of Government Law College, Puducherry, I would also like to thank the dignitaries on and off the dais. I would also like to thank the administrative officers of Government of Puducherry, security personnel, and most important, the participants of the program who have shown faith in us, the students, the media person, hotel management. Thank you so very much. And before I end, I would fail in my duties if I thank my honorable principal, Professor S. Srinivasan. We would not be here, we would not be able to enjoy these enlightening sessions unless he was here and guided us to organize this. Thank you so very much, sir. Thank you.
Now the inaugural session is over. Now we'll be taking a tea break of 10 minutes. So all of you are requested to have tea. Okay, sorry, before that I forgot. National anthem.
जन मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जाहे तव शुभाशिष माहे गाहे तव जय दाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Okay, now all of us can have a 10 minutes tea break before the session. 10 minutes. Within 10 minutes, all of you are requested to gather here for the session. Strictly 10 minutes.